We decided that I would go first, and there's some good reasons for this. It's really a delight to be here with Dean Chemerinsky. He's an extraordinarily busy man. I try never to bother him. It means I don't get to see him as often as I'd like to. And we are the polar opposites on most things. The dean is a justly famous progressive, or if that term has too much baggage these days, I think you would accept that you're a reform liberal, sort of being a very old and venerable tradition. And I am an old-fashioned Reagan conservative. I emphasize old-fashioned because Reaganism is out of fashion in the Republican Party today, but that's a subject for another time. I like to say that being an inmate at Berkeley, as I describe it to my conservative friends, has one of the great perks is I get to be the president of the Berkeley Republican Club, and I also get to be the member. And I got joke works in San Francisco too, doesn't it? Okay. So on issues of the Constitution, things like the Electoral College, the composition of the Senate, the Second Amendment probably, constitutional originalism. I consider myself an originalist, although these days I say you have to go to the Baskin & Robbins store of originalism because there are at least 31 different flavors of it. And the Dean Chemerinsky's most recent book is a full-throated attack on constitutional originalism. So you can see that we are pretty far at the opposite ends of the field. But on this issue of freedom of speech, freedom of expression, the boundaries of freedom and art, we're very close together. But I do think there's two things for us to work through together today. First, individual opening statements, and then in some back and forth between us. Is I think we may have some different reasons for arriving at a similar place or the same place, and it might be useful to go through some of those different avenues to it, because that might be helpful. Second, I think there may be a small gap between us on some aspects of this issue of freedom of speech and freedom of expression. Remember, by the way, that there's really no sharp dividing line between free speech and these controversies and freedom of expression as it's important to artists. And I want to draw out some of these possible areas of disagreement because in an odd way, I may be slightly to the dean's left on this subject, which is a really hard thing to do. I have to say that, Dean, or I lose my Federal Society membership card. My main point, here I think is where our general agreement starts, is that the boundaries of freedom and art are not legal, with a couple of very tiny exceptions, like the old Miller standard on obscenity. I think it's still around, but not much. They're not legal, occasionally political, although not really on the national level. I think they're entirely, these days, cultural and maybe institutional. Delia mentioned, and she brought to my attention this story in the BBC about the school district in Florida. It was the Tallahassee Classical Academy, and right away you have a clue here that something interesting is going on. The story doesn't explain it, but it's no doubt one of these charter schools inside the public school system. If it's a classical academy, it's doing a classical curriculum. That's a conservative project in K-12 education these days, and the principal was fired after a teacher proposed showing the replica of the statue of David to, I don't know, fifth or sixth grade or something like that. And it does seem kind of silly to me. Although there's lots of other controversies like this that pop up around the country. And at that point, I always recur to Mark Twain's famous line that God created idiots, that was just for practice, then he made school boards. Always worth keeping that in mind. But mentioning Mark Twain does bring to mind the kind of things that are going on not a huge scale, but more than one place. And that's where, let's start with literature. Huckleberry Finn has been dropped from libraries, school libraries, and school literature curricula. To Kill a Mockingbird, both for similar reasons. In the case of Huckleberry Finn, racial stereotypes, the use of the N-word. To Kill a Mockingbird, similar issues. One that amazes me is that I'm so old that when I was in high school, back around the time of the Boer War, Catcher in the Rye was the sort of, not Sammy's novel exactly, but it was the one that was kind of suppressed in conservative school districts. Today, it's under attack by mostly the cultural left for being racist, misogynist, ableist, and elsewhere. So it's funny how these places change. That's also not new. There was, if you know the history of this, lots of suppression decades ago of Hemingway, of John Dos Passos. You can go on down the list. One of my favorite obscure books, the first novel of John Howard Griffin. You may know him better as the author of Black Like Me in the 60s. His first novel was called The Devil Rides Outside. Almost no one knows about it or reads it. But it was the subject, and it's, by the way, it's a pious book. It's popular among some Catholic readers because it's set in a monastery. And yet it was banned in Detroit because of some of the sexually explicit scenes narrated in the book. And the Supreme Court in Butler versus Michigan in 1952 threw out that ban on the book. And all right, lots of ironies abound here in this long story. Some other examples recently. Last year at Hamline University in Minnesota, a longtime adjunct professor of art history was dismissed after showing a 14th century painting of Muhammad in an art history class, for which the professor, it was Erica Lopez Prater, she had given lots of fair warning. I'm going to show this picture. I know that for some Muslims this is considered unacceptable or blasphemous. That's not universal, I understand, although I'm no expert in it. And in fact, after she was dismissed from Hamline University, so she lacked the protections of tenure, the local chapter of the Council on American Islamic Relations said, yes, absolutely, she was insensitive, it's blasphemous, it's offensive. The national organization of the Council on American Islamic Relations said just the opposite. No, it's perfectly acceptable. This was actually a wrong move to fire the professor for doing this. I noticed, I was pleased to see that the photo of Jackson Pollock a few minutes ago still had a cigarette in his lips. There is this move now to airbrush cigarettes out of old movies, or some old artwork. Every once in a while you'll see some classic old black and white picture, and someone's got a pose where it's obvious there was a cigarette there, and now that's just some odd gesture. Right? And, there's some movies where cigarettes are a plot point. Like, I don't know, Thank You for Smoking, the great movie about Christopher Buckley's comic novel and tobacco industry. It'd be hard to airbrush the smoking out of that and still have it be coherent at all. It'd be a 5-minute movie, I guess. The current situation, where a lot of our fellow citizens are quite upset about the catastrophe in the Middle East. So there's a Google Doc going around. I just learned about it last week, and it's, is your author a Zionist? It's up to over 200 names now, and I want to encourage boycotts of certain writers. It may or may not make their future prospects for getting things published more difficult. I don't know, but there's that going on. After the Russian invasion of Ukraine here 2 years ago, there was a move by orchestras and the performing arts to cancel scheduled appearances by Russian artists, and orchestras canceling planned performances of Russian composers. So, Tchaikovsky, Rachmaninoff, as though they have some blame in the current situation. Again, not new. There was lots of anti-German sentiment and suppression of German literature and art in World War I. Less so, I think, in World War II, but still some. Another thing happening right now, again, it's not legal or even political, but cultural and who controls the institutions. So there's a Richard Norton Patterson, a novelist who's published over 20 novels that have sold well. Finished a novel called Trial that involved a number of minority characters for whom he conducted extensive interviews to try and get it right. It was rejected by 22 publishers, even though he had one of the most prominent agents, because it's now, and he's not the only person this has happened to, it's now the convention that white authors in particular are not supposed to write about minority characters. As he put it, the council used to be write what you know. Now the council is stay in your lane. We'll see how this all works out. I'll just close with a couple of things where the law does bear on this a little bit, and this is where I'll want to engage the dean a bit. Long ago, the Supreme Court decided in a long series of cases going back decades that freedom of expression, meaning, of course, artistic expression, is deserving of the same protections as freedom of speech under the First Amendment. That included, nude dancing. That was one of the more famous ones. Dancing is expressive, although the cases are a little confused about this and try and reserve some room for some subtle distinctions that you get a headache trying to work through. But nonetheless, that's one. There was two cases, one 1992, one 2003, involving cross-burning. And the first one is where the court struck down an ordinance in St. Paul, Minnesota, that had banned cross-burning, especially when it was targeted at minorities. And the court, in a 9-0 ruling, by the way, so it had everybody on board, said it was too broad. It suppressed speech that would be legitimate in general, but only when attached to what we call in civil rights language a protected class. Okay, fast forward to 2003, the Supreme Court struck down by a divided vote this time a cross-burning statute, an anti-cross-burning statute in Virginia. Also, the statute there had a more narrow language than the one in St. Paul, Minnesota. But one of the things that Justice O'Connor wrote in her majority opinion was, I have the exact quote, but I'll set it up by saying, sometimes cross-burning can be part of artistic expression. Here's the actual quote. She said, cross-burnings have appeared in movies such as Mississippi Burning and in plays such as the stage adaptation of Sir Walter Scott's The Lady of the Lake. Well, I'm not sure it's quite beyond us, and this is where I'm going to want to engage the dean some. I'm not sure it's quite beyond us to be unable to make an intelligible distinction, and maybe, I'm not entirely persuaded myself, but maybe an intelligible legal and political distinction between an expression that is meant to be in the service of artistic goals, like a movie dramatizing the civil rights era or other things you can think of, and a cross-burning that's meant to be intimidation. And although I agree with the dean, I think I'll let him explain his position on hate speech, rather than try it myself. But maybe we should think hard about that and maybe arrive at the same place and where we are right now. But I think we need to reopen some of these questions, be candid about it. Finally, I am a big believer in Dostoevsky's famous line, "Beauty will save the world." And I guess my final resting point is, and why I am hesitant to press this idea that maybe we need to think about whether there are some intelligible, possible legal boundaries on expression that could have bad effects, is I think that the more that we can accomplish by opinion, the less we'll have to do things by law. So I'll stop there and yield the floor to the dean.
It's an honor and a pleasure to be part of this conference and great to be talking with Steve. As we talk about the First Amendment in art, I think we have to start with the most basic principle. Under the First Amendment, all ideas and views can be expressed, period. Government never has the power to censor or punish speech just because it's offensive, even if it's very deeply offensive. To talk about a case that arose from a different medium, music, a case from several years ago in the Supreme Court, it's a case called Mattal versus Tam. It involved a rock group, Portland, Oregon, and the leader of the rock group was Simon Tam. They decided that they wanted to call their band the Slants. Slants is a derogatory term sometimes directed at Asian Americans. They said that their goal in using the title The Slants was to appropriate back to the Asian community the word slants in the way in which queer had been appropriated back to the gay and lesbian community. They wanted to trademark the name of their band, Slants. And there's a provision of the Lanham Act that governed trademarks that said that there couldn't be the trademarking of something if it was derogatory or disparaging to any group. The United States Supreme Court unanimously ruled in favor of Simon Tam and the group. And the Supreme Court made it clear that the government can't punish speech or decide what benefits to give to speech or not give just on the grounds that's offensive, even very deeply offensive. Steve, at the end of his remarks, was talking about hate speech. Almost every European country has a law that prohibits hate speech. But under the First Amendment, hate speech is clearly protected. The most frequent question that I get in talking about, say, speech on campus is, where is the line to be drawn between free speech and hate speech? And my answer always is, that's a false dichotomy. The Supreme Court repeatedly has made clear that hate speech is protected unless it rises to the level of being incitement of illegal activity or constitutes a true threat. The two cases that Steve mentioned illustrate this. The first he talked about was RAV versus City of St. Paul in 1992. It involved a St. Paul ordinance that prohibited burning a cross or painting a swastika, deeply offensive symbols of hate, in a manner likely to anger, alarm, or cause resentment. And as he pointed out, 9-0, the Supreme Court declared that ordinance unconstitutional. The other case he mentioned was Virginia versus Black from 2003. This involved a Virginia law that prohibited cross burning. 8-1, the Supreme Court declared that unconstitutional. Though Justice O'Connor did say in the opinion, if the cross burning becomes a true threat, then it can be punished. So Virginia versus Black involved two matters that came to the Supreme Court together. One involved a Klan rally on an isolated farm, and they had burned a cross. The other involved two men who had burned a cross on the lawn of a home, a family recently bought by an African-American family. And the Supreme Court said the Klan could not be punished because there were no onlookers. There wasn't intimidation or a threat. But the men who burned the cross on the lawn of the home purchased by the African-American family could be punished because there was a true threat. Why does our country protect hate speech when most other Western nations don't? In part, I think it's because of the impossibility of defining what we mean by hate speech in a manner that's not unduly vague or overbroad. Any regulation of speech under the First Amendment has to be clear about what's prohibited and what's allowed. In the early 1990s, over 360 colleges adopted hate speech codes. They were well-intentioned, but everyone to come to court, without exception, was declared unconstitutional as being impermissibly vague and overbroad. But I think there's a more important reason why hate speech is protected under the First Amendment. That's because it expresses an idea. It's an offensive idea, but under the First Amendment, all ideas and views can be expressed. I want to talk for a few minutes about the intersection of the First Amendment and art, and then I'll conclude, as Steve posed, by talking about why I think the Supreme Court has got it right in the cases that I'm discussing. Art and the First Amendment intersect in a number of ways. One, which Steve alluded to, is with regard to obscenity. The Supreme Court has been clear that obscenity is a category of speech only protected by the First Amendment. In Roth versus United States in 1957, and under the liberal justice William Brennan said that obscene material is, quote, utterly without redeeming social value, making it prohibited. Of course, many great works of literature, works of art, were censored or punished under the definition of obscenity. Steve briefly mentioned a case that articulated the current test for obscenity. It was Miller versus California in 1973. And there the court said that material that can be punished as obscene only meets all of three requirements. First, it must appeal to the prurient interest. That means, in the definition provided by the Roth case, it has to, quote, excite lustful or lascivious thoughts. Second, it has to be patently offensive under the law prohibiting obscenity. Any law prohibiting obscenity is to delineate what depictions will be deemed patently offensive. And third, taken as a whole, it must lack serious redeeming, artistic, literary, political, or scientific value. The test of obscenity came in a manner that very much applies to art, in a matter that arose in Cincinnati. It started in 1989 and led to a trial in 1990 involving the photographer Robert Mapplethorpe. You might remember he had an exhibit. It was about 150 photographs. It involved homoerotic art. And it had displayed in a number of cities before it came to Cincinnati. And when it came to Cincinnati, there were objections. And the day after the exhibit opened, the local district attorney prosecuted the director of the art museum in Cincinnati, saying that 7 of the pictures in the Mapplethorpe exhibit were obscene under the Miller test. An issue arose: what does it mean to say the work taken as a whole? Do you look at all 150 pictures or just the 7? The trial court judge said just the 7. Makes you think, if this were a book, do you just look at the pages that I always earmarked as a teenager, or the parts of the movie that have the sex scenes? But that's what the judge said, and it went to trial. And in 1990, after a jury trial, the jury acquitted the director of the art museum, saying it wasn't obscene material. Obscenity prosecutions have largely gone out of fashion. Now, used to be, especially if you look at the Supreme Court cases, most of the obscenity prosecutions were then known as adult movie theaters. Another leading Supreme Court case about obscenity was Paris Adult Theaters versus Slayton. It was a movie theater that showed adult movies. But of course, first the development of VCRs and then the internet make it unnecessary for people who wish to see obscene material to go to a movie theater. And the Supreme Court said in Stanley versus Georgia, no one can be punished for having obscene material in their own home. And so obscenity prosecutions have become really a thing of the past. But I've always believed that there will be another time when those who dislike sexually explicit material will revive obscenity prosecutions. And the Heritage Foundation has released what they call Project 2025, which they think should be a blueprint if Donald Trump is elected president in November. And right at the beginning, and again just a few pages later, one of the things that they call for is enforcement of obscenity laws in pornography prosecutions. So if the new administration is elected, and if they do follow this and make a priority of going after what's regarded as obscene and pornographic, I think you again could see going after works of art, because it is the nature of art to push boundaries. It's the nature of art to offend. It's the nature of art to challenge our sensibilities. A second way in which the First Amendment is intersected with art is when the government is giving subsidies. And there's a Supreme Court case about this, National Endowment of the Arts versus Finley. You might remember that there was an exhibit by an artist named Serrano that was displayed that involved a crucifix in a jar of urine. It was, and I will tell you the exact title from it, I quote, "The Piss Christ." And this then led Congress to amend the statute that provided for the National Endowment of the Arts. That's one of the things that should be taken into account when the National Endowment of the Arts give money is standards of decency. And the question is, did this violate the First Amendment? And the Supreme Court, in an opinion by Justice O'Connor, said no, that this was content neutral. In essence, the government could choose what art it wanted to fund and what art it didn't want to fund. But the problem is, this is not content neutral. It's very much content-based. And the idea of the First Amendment is that the government can't choose what speech to allow or prohibit, what to fund or not fund, based on the viewpoint expressed, or even based on the subject matter expressed. Hard to reconcile Justice O'Connor's opinion with that. And yet, when I teach First Amendment law, and I did last fall, and I'll do it again next fall, one of the things I say to my students is that I think the hardest question under the First Amendment is, what about the situations where the government has no choice but to make content-based determinations? It can't fund all art. It's going to choose to fund some art and not other art. How then do you apply this First Amendment notion that the government can't make content-based choices? But NEA versus Finley said at least when it's the government giving money, it can make determinations on the basis of decency. A third area where this arises, with regard to the intersection of the First Amendment and art, is in the school context. And Steve mentioned examples of this. The recent example in Florida of a school not wanting children to see pictures of the Statue of David, or the instance in Hamline University in Minnesota where the professor was, or the longtime lecturer was to lose her job on account of showing the depiction of Muhammad from the 14th century. I think it's important here to draw a distinction between high schools or even lower schools as opposed to colleges and universities. High schools, lower schools, administrators are given a great deal of discretion with regard to what would be in the curriculum, what it is that children will be able to see or not see. Now, the Supreme Court made clear in Tinker versus Board of Education in 1969, students and faculty don't leave their First Amendment rights at the schoolhouse gate. But at least when it comes to curricular decisions, schools are given great latitude. They get to define their educational mission. They get to restrict speech to advance it. One of the hard issues here that's now split the lower courts is what about taking books out of a high school library? There's only one Supreme Court case that's ever addressed that, Island Trees Board of Education versus Pico. There's no majority opinion, and the lower courts are struggling with this question of what about taking books out of libraries? And in this sense, book banning is not a thing of the past. It's very much a reality in 2024. When it comes to college universities, it's very different. Now, part of this is, at least for faculty, there's the notion of academic freedom. Faculty have great latitude in what to cover in their classes, and this would apply to the professor at Hamlin, as well as to their scholarship. Also, with regard to the First Amendment, courts have found greater protection with regard to the college and university level than with regard to the high school level. So punishing students or punishing faculty for the views or ideas they expressed much more likely to violate the First Amendment in the college-university context than in the high school context. Well, Steve said he wanted to talk about why do we provide this protection for speech. And there are many different theories that have been advanced as to why free speech is a basic right. My answer ultimately is about distrust of the government. I don't want the government to have the power to decide what ideas or views can be expressed. And I mean government at all levels. I don't want the chancellor of a university or the dean of a law school to decide that these are the ideas and views that are okay on campus, and these are the ones that aren't. I don't want the California legislature, or the legislature in any state, or the president, whatever the political party, or Congress to say, these are the ideas that are okay, and these are the ideas that aren't okay. To me, the First Amendment is based on the basic notion that it's for all of us to hear the ideas and views we want, for all of us to decide for ourselves. Ultimately, the First Amendment then is based on a faith that we as a society will be better off letting all ideas and views be expressed than we would be in a society where we're going to give the government the power to determine what ideas and views we can hear. And that's a faith that I have, at least most of the time. Thank you.
By the way, I'm in heated agreement with the very last thing you said about one reason for taking a tough view of the First Amendment, toughly defending it, is don't trust the government. That's usually my business card. But I completely agree with that, and I generally agree that all ideas should be expressed, or have the ability to be expressed. Let's work a little backwards, though. I also agree with you that I'm very uncomfortable with a lot of the hate speech laws in Europe. And there have been some enforcements of that I disagree with and thought were more political than actually connected to specific harms, but whatever. Big divisions of opinion on that. But as you know, Germany has an extra special tough set of these laws going back, of course, to the end of World War II. So they not only banned a Nazi party or any parties like it from being formed, they've also, I believe it's still enforced, they also do censor images. This would be art, anti-Semitic cartoons, for example. Dean, do you think Germany's law goes too far? Do you think they're mistaken to have done that?
I think such a law in the United States would be and should be unconstitutional. Germany has a different context and a different history, but I think the same principles should apply generally, that all ideas and views should be able to be expressed.
Yeah. Oh, sorry. Go ahead. I agree with you about that. Although, am I fair to restate that by saying, here's the way I put it, the circumstances there were so extraordinary, and our doubts about whether it could come back, still today, right? We worry about, maybe not, okay. That the circumstances were so extraordinary as to justify it. That's the way I put it. And, okay, go ahead.
On December 5th, 3 university presidents testified before a House committee, and they were asked whether or not the advocacy of genocide would violate the school rules. Now, it's easy to armchair quarterback and say, if I were there, what would I have said? I've had months to think about it. I think the problem with their answer was that they gave a very logical, correct answer to the First Amendment, but to a question that required an emotional response. But the reality is, under the First Amendment, even the advocacy of genocide is an idea that's protected so long as it doesn't rise to the level of incitement of illegal activity or a true threat. Senator Glazer has introduced a bill into the state legislature that would prohibit advocacy of genocide on campuses in California. Here's the problem with that. Some believe that what Israel is doing in Gaza is genocide. Could those who would defend what Israel is doing then be censored under that law by saying that they're advocating genocide? Some believe that abortion is a form of genocide. Could anti-abortionists then say that they're going to censor the speech that calls for abortion as censoring a form of expression that calls for genocide? So my position is, and I think it's the First Amendment position, that we protect the speech even though it's distasteful, even though it's deeply offensive, and allow others to respond to it. I answered your question, Steve, intentionally by saying, in this country under the First Amendment, what the law should be. I hesitate about speaking of any other country, and yet deep down I believe that the same principles apply, that people are much better off being in a society where they can express their ideas and views as opposed to a government to tell them what they can and cannot hear.
Yeah, so no, again, I'm absolutely with you in principle and in practice. I don't want judges or politicians deciding what people can and can't say or express themselves in art. But the example that I just brought up was a real world example that we ought to wonder about extrapolating. Now, I mean, I've long, what's the famous Sinclair Lewis novel, It Can't Happen Here, from the late 30s, right? It sort of comes back every now and then as we wonder about, we wonder about a particular candidate on the ballot this year, right? So incitement, you say, that is a clear boundary. We can talk a bit about whether art can incite people. I mean, there are occasionally examples of artistic expression that causes riots, not so much in this country, but elsewhere. What about intimidation? And I'm thinking in particular of the poster on campus of you that I can say more about unless you want to describe it.
Let me talk about the law, and I'm glad to talk about that poster if you want to. It's important to distinguish the colloquial use of the word incitement from the legal test for incitement. There is a legal test that comes from Brandenburg versus Ohio in 1969. It says that speech can be punished as incitement if there is a likelihood of imminent illegal activity and if the speech is directed at causing imminent illegal activity. It would be very difficult, if not impossible, for a work of art to meet that test for incitement. Now, imagine an angry crowd on a campus, and imagine a speaker that exhorts that crowd to commit acts of violence. That could meet the Brandenburg test, but I don't think a work of art would meet the requirement of imminence that's in the Brandenburg test. Now, intimidation is not a category of unprotected speech, but closely related, the Supreme Court has said that true threats are a category of unprotected speech. In Encounterman versus Colorado last year, the Supreme Court said that it's a true threat if somebody acts with reckless disregard that the speech be regarded as a threat of violence. If they act with conscious disregard that a reasonable person would fear imminent violence. Imagine a student walking across campus, and imagine that a group surrounds that student and yells things, maybe anti-Semitic, maybe racist. And imagine the student reasonably fears for his or her safety. The students who surrounded that individual could be punished for a true threat, even if no blow is struck, because there was certainly at least reckless, if not an intentional, making the person fear for safety. The poster that you talk about was protected by the First Amendment. The context, and I fear that most people already know it, is that my wife and I hosted dinners at our house for the graduating class. Usually do dinners at the beginning of law school as students starting. We didn't do that for the class that graduated last Friday because of COVID. They started in the fall of 2021. A week before these dinners, which were April 9th, 10th, and 11th, a poster appeared online and on all the bulletin boards in the law school, and it called for the boycott of the dinners. It said, "Boycott the Zionist Chem," and it had a picture of me holding a bloody knife and fork and with blood around my lips. I believe that poster was blatantly anti-Semitic, invoking the old, awful trope, it's anti-Semitic, of blood libel. a number of people complained to me saying that the poster being on bulletin boards in the law school made them feel unsafe. I believed that it was speech protected by the First Amendment and that I'd violate the First Amendment if I had taken the posters down. I continued to believe that that's what the First Amendment required, though I was enormously upset and deeply offended by those posters.
Yeah, I mean, I brought it up not to put you on a spot about that particular thing, but because it does connect to the question of art. Because the poster had just been a poster of text saying, "We protest Zionist Dean Chem." By the way, why could they do the rest of your name? Is there a spelling problem? Too long?
I don't think they have space on the
That's my friend. What, Dean Chem? I thought Chem was like, the abbreviation for chemistry one. Okay. If it had just been the text, it's absolutely crystal clear. It's free speech, even if it's, really ugly. It was the picture that drew the attention, right? That's what made it a news story. And so let me press this question a little further. You are not going to be intimidated. This I know. On the other hand, what are we going to, and of course, one poster alone is not going to move the whole world like a fulcrum, but what are we going to think if we if we show up at school in September at Berkeley or Harvard or wherever, and we find that the number of Jewish students who have enrolled has fallen by 3/4 because of the general campus climate, of which there's many other parts, not just your poster, but I want to bring it up as a kind of thing that's an exclamation point on the problem. What are we going to think then? And what are we to make of all that? I honestly don't know, but it bothers me a lot right now.
There is a tension between Title VI and the First Amendment that I want to explain, and I think it provides the answer to your question. Title VI of the 1964 Civil Rights Act says, recipients of federal funds cannot discriminate on the basis of race or ethnicity. And that includes that they're not allowed to permit harassment on the basis of race or ethnicity. The First Amendment, though, says that speech is protected unless it's in a category that's outside the scope of the Constitution. Well, how do you mediate that? Because if the speech is harassing, as you say, and would discourage students from being there, doesn't it violate Title VI? And on the other hand, if it's protected by the First Amendment, what can the school do about it? And just about 2 weeks ago, the Assistant Secretary of Education, Catherine Lehman, issued a Dear Colleague letter that I think provides the right answer to this. What she says is that when there's speech that would constitute harassment, but is protected by the First Amendment, the key is that schools can't be deliberately indifferent. That doesn't mean they can or should punish the speech, but it does mean they must do something. It might be administrators speaking out against the speech. It might be protection for the students. It might be support. It might be trainings and education. I litigated a case that I won in the United States Court of Appeals for the Fourth Circuit a few years ago that involved Mary Washington University, a public school in Virginia. There was a campus debate about whether to allow Greek life. And 3 women wrote an op-ed for the campus newspaper opposing it, saying when there's more fraternities on campus, there's more violence against women. They then got targeted over the social media platform Yik Yak with over 600 messages, most quite vile, some threatening them with rape and murder. And they went to the campus administrators and said, you need to do something to protect us from this. And the campus administrator said, it's anonymous speech over social media. It's not our responsibility. The campus even put on its website that it had no responsibility for anonymous speech over social media. The women sued. They lost in the trial court with the federal district court judge saying that this is just anonymous speech over social media. It's First Amendment protected. I argued the case in the Fourth Circuit, and the Fourth Circuit ruled in their favor. And what the Fourth Circuit said was, when there's speech that constitutes harassment, the school can't be deliberately indifferent. It doesn't mean necessarily punishing the students who engaged in the speech over Yik Yak, but it has to mean the school has got to do something. And the Fourth Circuit gave the same kind of list as Assistant Secretary Lehman did. So my answer to your point is that schools have to do things to make sure that the safety of Jewish students and all students are protected, that it's a welcoming environment for Jewish students and other students, but it doesn't mean punishing the speech if the speech is protected by the First Amendment.
All right, last question here, since we're almost out of time. And I want to do a classic, not exactly hypothetical, but I want to draw back to that murky borderland between art and speech and invoke performance art. One of the things that come up lately is, there are these old statutes written back during the Klan era, you might say, where you can't wear masks in public or in protests. And of course, we're seeing a lot of people wearing masks on campus now for various reasons. And so here's a hype. But look, a person could say, I think, oh, I'm not a Klansman on my way to a Klan rally. I'm on my way to a play. Or this is performance art. I'm trying to make a subtle statement. I'm not actually saying anything. How would you react to the following scenario? Suppose, I don't know, 8 or 10 people dressed in Klan apparel stood out on the sidewalk, a public sidewalk, in front of your house, or a black family's house. It doesn't have to. I don't have to make it you specifically, and said nothing, but just stood there for 2 or 3 hours. What's your evaluation of that? Is there a remedy there?
Wearing the Klan outfit is protected under the First Amendment. There is a point at which targeted residential picketing can be regulated. We didn't talk here, because it usually doesn't come up in the art context, that there can be time, place, and manner restrictions with regard to speech, so long as they're content neutral, so long as they leave adequate alternative places for communication. And in connection with this, the Supreme Court, in a case called Frisbee versus Schultz, said that the government can prohibit targeted residential picketing at a certain point. So 3 or 4 hours, no, they have the right to come to my house for 3 or 4 hours. But if they come over a long period of time and target just my house, the Supreme Court in Frisbee versus Schultz said that there can be a time, place, and manner restriction to limit the number of hours they can be outside my house.
I think we've run out of time. Dean, thanks very much. That was fun to do. And I think I agree with you 99%. So, thank you.